You know the words. You've never been arrested and you know the words. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. You know them from television, from films, from 100,000 hours of crime drama absorbed the way you absorb a song you never chose to learn. You could recite them right now, half asleep, in the correct order. And you believe they're old, ancient even. Part of the founding architecture of the country, carved somewhere near the Bill of Rights, spoken by every officer to every suspect since roughly forever. They are younger than the Ford Mustang, younger than the Beatles' first American tour, younger than most people's parents. Before the summer of 1966, a police officer in the United States could put you in a room, close the door, and ask you anything he wanted, for as long as he wanted, and was under no obligation whatsoever to tell you that you could refuse. Not one word. It's the reason a man who confessed to a violent crime walked out of a courthouse a free man. It's the reason the phrase lawyering up exists in the language. It's the reason that within weeks, police departments across America were printing a paragraph on wallet-sized cards and handing them out at roll call because officers couldn't be trusted to remember it correctly. And it's the reason the most famous sentence in American law is named after a man who was, almost certainly, guilty. His name was Ernesto Miranda, Phoenix, Arizona, March of 1963. And the strangest part of this story isn't how he won. It's what happened to him 13 years later, on the floor of a bar on West Washington Street. Now, before we go any further, I want to be honest about something because this isn't a conspiracy story. The system that existed before 1966 wasn't hidden. It wasn't a secret. It had been studied, documented, and formally condemned by the federal government of the United States in 1931, and then it carried on, essentially unchanged, for another 35 years. This isn't a story about hidden evil. It's a story about something everyone could see and nobody could stop. And it starts with a right that already existed. The Fifth Amendment was ratified in 1791. No person shall be compelled in any criminal case to be a witness against himself. It's right there. It's been there the entire time. So the headline I opened this video with is technically a lie, a useful one. You did have the right to remain silent in 1965. You just had no way to use it, because that right, as it actually functioned, had 3 holes in it big enough to drive a squad car through. The first, it applied at trial. In a courtroom, in front of a judge, with a jury present and a stenographer taking it down. It said nothing at all about a basement room at 2 in the morning with 2 detectives and no witnesses. The second, until 1964, the Fifth Amendment restrained only the federal government, not the states. And virtually every arrest in America, then and now, is a state arrest. Your local police department was, for constitutional purposes, operating outside that sentence entirely. And the third, which is the one that matters most, there was no duty to tell you. None. A right you have never been informed of isn't a protection. It's a rumor. So what did courts actually use instead? A thing called the voluntariness test. After the fact, sometimes a year after the fact, a judge would look at the totality of the circumstances and decide whether your confession had been voluntary. How old were you? How educated? How long were you held? Were you fed? Did you sleep? And notice who that test was really built for. If you were a lawyer's son, arrested in a good suit, with a family that could make phone calls, you had circumstances a judge could see. Education, standing, someone on the outside asking where you were. If you were poor, or 17, or couldn't read the form in front of you, or nobody had noticed you were missing yet, those were exactly the circumstances that made a confession easier to get, and exactly the ones a judge would later be asked to overlook. The test protected the people who least needed protecting, and it ran backwards. Every other rule in criminal law tells you in advance what you may not do. This one didn't. It said, do whatever you want, and we'll decide later whether it counted. And later was long after that confession had already been read aloud to a jury. There's a phrase for what filled that vacuum, the third degree. In 1931, a commission appointed by President Herbert Hoover, the Wickersham Commission, published a volume with the almost unbelievable title, Report on Lawlessness in Law Enforcement. It documented, department by department, American city by American city, the systematic use of violence and deprivation to extract confessions, beatings, prolonged illegal detention, denial of food, water, sleep, threats against family. This is not an allegation from a critic. This is a federal government finding, published, printed, and shelved. 5 years later, the Supreme Court heard Brown v. Mississippi. 3 black tenant farmers had confessed to murder. One of them had been hung by a rope from a tree, let down, and hung again. All 3 had been whipped until they said what the deputies wanted them to say. A deputy admitted the whipping openly at trial. because in that courtroom, in that state, in that year, it wasn't understood as something you'd need to hide. The confessions were the entire case. The trial took a single day. The court threw them out. Sit with what that ruling actually represents. It took until 1936 for the Supreme Court of the United States to establish that a confession beaten out of a man could not be used to convict him. Then, in 1944, Ashcraft v. Tennessee. 36 hours of continuous interrogation under a bright light, officers working in relays so they could rest while he couldn't. No bruises, no marks, nothing to photograph. The court called it inherently coercive, and in doing so, quietly acknowledged that you don't need to touch a man to break him. And here's the twist that most tellings of this story miss. The third degree wasn't abolished. It was professionalized. Bruises lost cases. Marks were evidence. So the technique moved inward, away from the body and into the mind. In Chicago in the 1940s and 50s, a former police officer named John Reid developed and commercialized a method of interrogation that required no violence at all. Isolate the subject in a small room. Project absolute, unshakable certainty of guilt. Cut off every denial before it's finished. Then offer him a morally acceptable excuse for what he did. You didn't plan it. She provoked you. Anyone would have. And minimize what admitting it will cost him. Even the room was designed. The manual specified it. Small, bare walls, nothing to look at, no clock, no telephone, no window. 2 chairs placed closer together than 2 strangers would ever sit. Nothing on the table. Because a man with nothing to look at eventually looks at the person asking the questions, and a man with nothing to fidget with has nowhere to put his hands. It worked extraordinarily well. It was published in manuals. Those manuals were commercially available. Any officer in America could buy one. And in 1966, the Chief Justice of the United States sat down and read them cover to cover, because he was about to quote them, at length, in the most consequential criminal ruling of the century. March 3, 1963, Phoenix, Arizona. An 18-year-old woman is taken from near a bus stop on her way home from work and raped. She survives. I'm going to leave it there because she was a person and not a plot point. 10 days later, police arrest a 23-year-old man at his home, Ernesto Miranda, a prior record, an 8th grade education, a history of psychological instability. He works nights on a loading dock. They put him in Interrogation Room 2, 2 detectives, roughly 2 hours, no lawyer, no warning, and, this is important, no violence. Nobody hit Ernesto Miranda. Nobody threatened to. There is no rubber hose in this story. 2 hours later, he confessed. And then he wrote it out by hand. Now here is the detail that this entire video has been walking toward. At the top of the confession form he signed was a pre-printed paragraph, standard, on every form in the building. It stated that the statement was being made voluntarily, of his own free will, with full knowledge of my legal rights. Nobody had told him what those rights were. He signed his name underneath a sentence certifying that he knew something no one had ever told him. And that paragraph existed for exactly one reason, not for Miranda, for the judge who'd read the file 8 months later, looking for signs of coercion, and find a signed declaration that there hadn't been any. It was the voluntariness test, pre-answered, printed in advance, waiting for a signature. His court-appointed lawyer was a man named Alvin Moore, 73 years old, working for a nominal fee. Moore objected to the confession. He was overruled. The jury convicted, 20 to 30 years. And I want to be clear about who we're talking about here because a lot of retellings get soft at this point. Miranda was not innocent. The evidence against him was real. This story does not end with an exonerated man walking into the sunlight. It ends with something much harder to sit with. A guilty man whose conviction had to be thrown out in order to protect everybody else. But hold on. There's an objection forming, and it's a fair one, so let's take it seriously. An innocent person would just say no. You'd say no. You'd shut your mouth. You'd ask for a lawyer. You'd wait. Wouldn't you? Here's why that instinct is wrong, and it has nothing to do with courage. You are alone. You have been alone for some hours now. Every denial you offer is cut off before you finish it. Not angrily, just calmly, as though you've said something slightly embarrassing. The 2 men in the room are not arguing with you about whether you did it. That question is closed. They are treating your guilt as an established fact of the universe, like the weather. They're friendly. One of them is sympathetic. And gradually the conversation stops being about whether you did it and starts being about why. And every version of why they offer you is a version that makes you sound like a person who got unlucky rather than a monster. And underneath all of it runs a single suggestion, never stated outright. The way out of this room is through a signature. There's one more thing working against you, and it's the thing people never account for. Refusing feels like an accusation. Saying I want a lawyer to a man who has spent 2 hours being reasonable with you feels like calling him a liar to his face. It feels rude. and most people will sign a document before they will be rude to someone in authority who is being kind to them. You think you'd hold. So does everybody. Among the DNA exonerations cataloged by the Innocence Project, cases where science later proved definitively that the convicted person did not do it, roughly 1 in 4 involved a defendant who had confessed. Read that again. 1 in 4. People confessed to murders they did not commit, in rooms where nobody laid a finger on them. If you still think you'd hold up in that room, tell me in the comments, but wait until you've heard how the rest of this went. Miranda, sitting in prison, wrote to the Arizona Supreme Court himself. He lost. Then the case was picked up by the ACLU and handed to a Phoenix firm, Lewis and Roca, who took it without a fee. 2 men led it, John J. Flynn, one of the finest trial lawyers in the state, and John P. Frank, a serious constitutional scholar. And the ground had already begun to move under them. 1963, Gideon v. Wainwright. If you're charged with a serious crime and can't afford a lawyer, the state has to give you one. 1964, Escobedo v. Illinois. A suspect who asks for his lawyer during questioning has to be allowed to see him. 1964, Malloy v. Hogan. The Fifth Amendment finally formally binds the states. 3 cases, 3 years. But look at the gap they left. Escobedo protected the man who knew to ask. What about the man who didn't know there was anything to ask for? That gap wasn't theoretical. In the 2 years after Escobedo, police departments and state courts across the country read the ruling in wildly different ways. Some treated it as requiring almost nothing, others as requiring nearly everything. An officer in one state and an officer 300 miles away were operating under 2 different constitutions. The court hadn't just left a hole, it had left confusion, and confusion always resolves in favor of the person holding the door. On the 28th of February 1966, Miranda v. Arizona was argued before the Warren Court, bundled together with 3 other cases raising the same question, which tells you the court wasn't there to decide one man's fate, it was there to write a rule. June 13, 1966, 5-4, Chief Justice Earl Warren writes for the majority, and Warren does something in that opinion that nobody expected. He quotes the interrogation manuals, directly, at length. The police profession's own instructional literature entered into the constitutional record as evidence against itself. He didn't need to call witnesses or prove misconduct in a particular basement. He didn't need to establish that anyone had been beaten, because the manuals had already explained, in a professional and matter-of-fact tone, why beating was unnecessary. He had the textbook, the holding. Before any custodial interrogation, a suspect must be told he has the right to remain silent, that anything he says can be used against him, that he has the right to an attorney, and that if he cannot afford one, one will be appointed. And then the part that actually mattered. Break the rule, and the confession cannot be used. Full stop. Because that was the missing piece. Not the right. The right was 175 years old. What was new was that violating it finally cost somebody something. It was not a new right. It was the first time the right came with a delivery mechanism. But was the court wrong? The dissenters thought so, and they weren't cranks. Justice Harlan and Justice White argued that the Constitution nowhere requires a script, that the court had invented a police procedure out of thin air and then called it a right, and that the cost of it would be counted in confessions never given, which means crimes never solved, and victims who never get an answer. White wrote plainly that guilty men would go free because of it, and his argument had a real edge to it, which is worth stating at full strength. A confession is not just evidence, it's often the only evidence. Crimes committed in private between 2 people, with no witnesses and nothing forensic to recover. Take the confession away and you don't get a fairer trial. You get no trial. The dissent's charge wasn't that the majority was being too kind to suspects. It was that the court had chosen an abstraction over the specific, identifiable people who would never find out what happened to them. The backlash was immediate. In 1968, Congress passed a statute attempting to overrule Miranda outright and restore the old voluntariness test. It sat on the books, largely unused, for over 30 years, until the Supreme Court finally confronted it in 2000 in Wickersham v. United States. And a conservative court, led by Chief Justice Rehnquist, a man who had spent much of his career criticizing Miranda, upheld it, 7-2, on the grounds that the warnings had become embedded in the national culture. And the flood of freed criminals the dissenters warned about, it largely never came, because roughly 4 out of 5 suspects hear the warning, nod, waive their rights, and talk anyway. Which raises the question this whole video has been walking toward. If almost everyone waives it, what exactly did we win? Because in the 60 years since, the right has been shaved thinner, 1 case at a time. 1971, an unwarned statement can still be used to attack your credibility if you take the stand. 1984, the public safety exception. In urgent circumstances, officers can question first and warn later. 2010, Berghuis v. Tompkins. A man sat nearly silent through almost 3 hours of interrogation, then answered one question, and that answer convicted him. The court's holding contains a genuine paradox. To invoke your right to remain silent, you have to speak. Silence alone doesn't count. 2013, stay quiet before you're formally arrested, and a prosecutor may point that out to the jury. 2022, Vega Viteco, violate Miranda, and you cannot be personally sued for it. The confession gets excluded from the trial. The officer walks away untouched. Look at the shape of that list. Not one of those decisions overturned Miranda. Every one of them left the famous words intact. The warning still gets read. The card is still in the squad car. What changed was everything underneath it. Who has to speak first, what counts as asking, when it applies, and what happens if it's ignored. The sentence survived. The machinery around it was quietly rebuilt. So here is the right as it exists today. You have the right to remain silent, but you have to announce it out loud. You have the right to a lawyer, but only if you ask correctly, because courts have ruled that a hedge like, maybe I should talk to a lawyer, is too ambiguous to count. And if an officer ignores every part of it, the penalty falls on the prosecutor's case, never on the officer, which means the only version that reliably works is 2 flat sentences, said clearly, and then nothing else at all. I am invoking my right to remain silent. I want a lawyer. No explanation, no context, no because. Anything you add is a door. Ernesto Miranda was retried in 1967, this time without the confession, and convicted anyway, largely on testimony from his common-law wife. He served his time. He was paroled in 1972, and in the years after, he did something almost too perfect to be true. He sold autographed Miranda warning cards on the streets of Phoenix, $1 or $2 apiece, his own name, printed on the rights he'd created, signed by the man himself. January 31st, 1976, a bar on West Washington Street, a fight over a card game. Ernesto Miranda is stabbed and dies on the floor. He is 34 years old. Police detain a suspect, and they read him his rights, the rights that carry Miranda's name, that exist because of Miranda's case, that were written into American law because 2 detectives in Room 2 never told Miranda he could stay quiet. The suspect listens, understands, and says nothing at all. Without a statement, there isn't enough to charge him. He is released. Nobody was ever convicted of killing Ernesto Miranda. The rule worked exactly as designed. It worked for the man who killed him. That isn't a flaw in this story. That is the story. A right that only protects the people we like isn't a right. It's a reward. The whole point of a rule is that it doesn't check who's standing in front of it. Ernesto Miranda proved that in 1966, and then 13 years later he proved it again. Most of what you assume is permanent about the country you live in turns out to be about 60 years old, decided 5-4, and quietly narrowing while nobody's paying attention. If you want these stories with the boring parts left in, the dissents, the numbers, the cases that came out the wrong way, that's what this channel is for. Next time, the Supreme Court case that decided the police have no legal duty to protect you, and the woman who found that out the hard way.